The Objective News Network, the Chief Justice of the Supreme Court of New Jersey, Stuart Rabner, is corrupted. Hello, this is John Hnatio reporting for the Objective News Network. This is our next report on the corruption of the judicial system in New Jersey. This time, we are going to share some more of the real evidence demonstrating that New Jersey's Supreme Court is corrupted. As reported in past stories, ONN has obtained access to the National Investigative Library of Evidence, or NILE for short, which is a massive computer library of evidence detailing the corruption of the federal and state of New Jersey court systems, written by the nonprofit think tank, the Institute for Complexity Management. In our past reports, we have already told you about the case of a small company in New Jersey called Demodulation Inc. that was owned by James O'Keefe Jr., the father of James O'Keefe III, the founder of conservative activist organization Project Veritas, and how a politicized Democrat justice system retaliated against the small business owner, destroying his company. It is a classic tale of the father being punished for the political sins of his son. But what makes this case study so truly remarkable is the amount of clear, compelling, and overwhelming evidence presented to the authorities that they simply refuse to investigate. As the Chief Justice of the Supreme Court, Justice Rabner has complete control over the disciplinary process for attorneys and judges throughout New Jersey and its courts. The lawyer disciplinary system in New Jersey consists of an Office of Attorney Ethics, OAE, a Disciplinary Review Board, DRB, and, of course, Judge Rabner, who oversees the entire process. Both the OAE and DRB report directly to Chief Justice Rabner. It was Judge Rabner who oversaw the disciplinary process in the lawyer misconduct complaints against 4 attorneys at the Callagy law firm who represented Demodulation Incorporated. After federal court judges Thomas Wheeler and William Martini dismissed Demodulation's legal cases, allegedly as the result of the egregious misconduct by both the government defense team, headed up by this man, Gary L. Houskin, and Demodulation Incorporated attorneys, the nonprofit Institute for Complexity Management, James O'Keefe Jr., and several other people filed complaints against the 4 Callagy law attorneys with Judge Rabner's Office of Attorney Ethics. At first, OAE simply refused to hear the complaints and intentionally stalled the process for over a year, trying to discourage the filing of any complaints at all. During this period, a local attorney named Nina Remson, representing the Office of Attorney Ethics, wrote several letters to ICM advising that the Office of Attorney Ethics would not act on the complaints because the 4 attorneys had not been prosecuted and already found guilty of crimes in a court of law. Here you can see an example of the Remson Letters that were received by ICM. Of course, in almost all cases, attorneys are subject to discipline, even though they are never criminally charged. The letter written by Ms. Remson was intended to discourage any complaints from ever being filed against the 4 attorneys in the first place. Ms. Remson was later appointed to the Superior Court of New Jersey by the approval of Chief Justice Rabner. However, with much effort and the threat of public exposure looming, OAE was finally forced to docket at least a few of the complaints made by ICM and other complainants. And then this man, Mr. Timothy J. McNamara, stepped into the picture. Mr. McNamara, the lead investigative OAE attorney, from the very outset made it his business not to, that's right, not to investigate the allegations of a racketeering, influence, corrupt organization, RICO, presented to him by ICM, James O'Keefe Jr., and the other complainants. OAE simply attempted to ignore the charges for another year to discourage the complainants from pursuing the matter any further. Despite the thousands of pieces of clear and compelling evidence presented to OAE as contained in the Nile database, Mr. McNamara sidestepped the charges made by the victims of the RICO enterprise in their complaints by simply failing to conduct any investigation of the charges and then completely disregarding the overwhelming evidence supporting the allegations made by ICM and other complainants. Instead, Mr. McNamara and his team simply read back the original rebuttal statements given to OAE by each of the accused attorneys' legal counsels, denying the charges, and then attacked the complainants for complaining in the first place. Let me show you what happened using the real evidence. Here's a copy of the original RICO case statement provided by ICM to Mr. McNamara's investigative team, the Department of Justice, the Newark FBI, the Attorney General of New Jersey, and Federal Judge Leda Dunn-Wetra, detailing the specific charges against each of the attorneys involved. As you can see from the evidence, the charges are very specific and highlighted in yellow. The complaint, when contrasted against the Office of Attorney Ethics Report of Investigation, shown here, demonstrates the intentional and total failure of the OAE investigators to investigate any of the specific allegations contained in the complaints filed by ICM with OAE and federal and state of New Jersey law enforcement officials. Now, to make matters much, much more serious, here's just a few of the letters that ICM sent directly to Chief Justice Rabner, reporting the egregious corruption of his own Office of Attorney Ethics. Judge Rabner never responded to even a single one of these letters. Instead, he chose to intentionally allow the corruption of his court to continue and grow. You see, as things turned out, Judge Rabner needed to discourage any actual investigation of the complaints to prevent the exposure of the corruption of the Supreme Court of New Jersey itself and the Federal District Court of New Jersey. Judge Rabner was aware that any real investigation of the complaints would, in fact, expose the existence of the RICO enterprise of New Jersey and federal judges, attorneys, and law enforcement officials, including former Attorney General of New Jersey, Mr. Gubir Grewal, U.S. Attorney Paul Fishman, and the Federal Bureau of Investigation, just as the original complaints to OAE by ICM and other complainants alleged. The evidence in the Nile database shows that this problem for Judge Rabner was terribly exacerbated by the actions of one of the 4 attorneys at Callagy Law. This man, Mr. Benjamin D. Light. The evidence is compelling and suggests that Judge Rabner worked with federal judges Leda Dunn-Wetra and Madeline Cox Arleo to protect Mr. Light from any lawyer disciplinary charges, to keep Mr. Light quiet about the Judge Madeline Cox Arleo problem. You see, Justice Rabner knew that any real lawyer disciplinary investigation would expose the egregious conflict of interest involving federal judge Madeline Cox Arleo, her husband's law firm, Arleo and Donahue, and Mr. Light, to churn legal cases in the direction of Judge Cox Arleo's husband's law firm, all in violation of her oath to the U.S. Senate Committee on the Judiciary. In the end, after 2 years in the hands of OAE's lead investigator, Timothy McNamara, and Judge Rabner, the complaints against all the attorneys were simply dismissed as meritless, based on the fraudulent OAE claim that there was no evidence of wrongdoing by the lawyers. It was now clear that the fraudulent reports issued by Mr. McNamara and the OAE were not designed to report the results of any meaningful investigation, but rather to suppress any investigation in the first place, while simultaneously destroying the reputations and personal credibility of the complainants and the victims of the RICO enterprise. After OAE issued their fraudulent reports, 2 of the complainants, the ICM principal investigator and Mr. James O'Keefe Jr., filed appeals of their cases to Judge Rabner's Disciplinary Review Board and this woman, Miss Bonnie C. Frost. In our next story, we will share some more of the remarkable evidence contained in the Nile database showing the wholesale corruption of Chief Justice Rabner's Disciplinary Review Board and the 2 corrupt attorneys who worked together with Ms. Frost and the DRB to fix any possibility of a proper appeal in the matter. It is what it is. For Friday, June 23rd, 2023, this is John Hnatio reporting for the Objective News Network. Thank you very much for watching our channel, and we look forward to hearing your comments on this important matter. Please subscribe, and we will see you the next time.